your rights as the parent of a special needs child? That is the focus of today's Legal Spotlight. I'm Christina, and I'm joined today by an attorney who focuses his practice on special needs education law. Kevin, thank you for joining me.
Thank you, Christina. I understand many parents out there are very confused and frankly afraid of what this upcoming school year may look like, especially those with special education students or students with 504 plans. Thankfully, you do have a lot of rights under those plans. For individuals that have special education needs are protected under the Individuals with Disabilities Education Act. You should have or should be evaluated for what's known as an IEP, an Individualized Education Plan. Keyword there, individualized, which means it's not a generic overlay for all students. Hey, this is the way it is. It needs to be tailored to the needs of your child. And the goal of this IEP is to provide a free and appropriate public education, a FAPE. Obviously, public education part, that's simple. That's what schools do. Free simply means you don't pay for it, the school does. What's appropriate then? That's where a lot of the finesse comes in, a lot of the questions, a lot of the discussions. And this needs to be provided to them in what's known as a least restrictive environment. That means that the child cannot just be put in a classroom with all special needs students, special education students, and have no contact with anyone else. That's what happened in the 70s, and they were providing no education to those students, and it was deemed terrible. So what they did instead was saying that as much as possible, these students need to be put with the general education students and only go to the next restrictive placement if we've established the more restrictive does not work. Then we have the 504 plans. This is authorized under the Rehabilitation Act of 1973, or the ADA. Now, 504 plans do look different than IEPs legally. In practice, they generally appear very similar. And best practices for schools is to follow IEP procedures for 504s, because it covers them. But what it explicitly provides is that you will receive reasonable accommodations for your student with a disability. An IEP under the IDEA is a legal document that is developed with the IEP team. You come together in meetings, you discuss the needs, you discuss the data of where the child currently is, you develop goals and the accommodations for those goals. Now, how do you even become eligible? Two things need to be in place. One, the child must have one of the listed learning disabilities under IDEA. While it is a finite list, there is one big catch-all called other health impairment. That's where you'll see eligibility under ADHD and other similar diagnoses. Then you'll also have the possibility for autism, blindness, emotional disability, intellectual disability, or a specific learning disability, which could be targeted to reading, writing, math, to really focus in on that. It should be noted that emotional disability, it's not a medical diagnosis. So you'll be looking at other factors in the child's life and behaviors to come to that eligibility. For other health impairment, there is one diagnosis you may see, which you'll hear often, but it's not grounds for eligibility, and that's ODD, oppositional defiance disorder. Yes, it can create issues in the classroom. Yes, it very well may feel as though it should be eligibility, but that standing in of itself is not. However, could connect back to emotional disability. So look into that. And all of these disabilities, they must be impacting, whichever one they have, the child academically. So for instance, if we're discussing ADHD, the child is unable to focus. So if they're unable to focus on the teacher or their work, then they will receive poor grades because of their disability, thus it impacted them academically. After IEPs and IDEA, there is the other avenue, which is through the American with Disabilities Act under Section 504, or it's generally known as a 504 plan for simplicity's sake. Now, a 504 plan benefits children with disabilities who are able to learn. It's not impacting them academically, but because of their disability, they need accommodations to access said education or services. Now, what is a disability? Unlike with IDEA, a disability is very broad under ADA. It has three different elements. One, it's a physical or mental impairment that substantially limits a major life activity. Obviously, physical mental impairment, easy to say. The argument comes in whether or not it substantially limits a major life activity. Two, there's a record of it. You look at the doctors, you can see, all right, this child was diagnosed. Then, number three is they're regarded as having that eligibility, that impairment, which look to the school, look to the parents, look to their environment. Are you seeing this impairment in their day-to-day life? Obviously, if they have a disability because they need a wheelchair, that's pretty straightforward. But if they have something such as high-functioning autism, they have a record of it. You may have a diagnosis, but because they're high-functioning, maybe some disagreement exists. So pay attention if they're regarded. Then, eligibility is intentionally left broad. We want schools to be able to determine that this child is eligible. We want it to be a broad definition to try to catch as many students as we can to provide them the accommodations that they need. And not just for school, but for extracurricular activities as well. We have IEPs and then we have 504s. So what's the difference? The one big key distinction as to which one your child will be eligible for is if the disability is impacting them academically. If it is impacting them academically, IEP. If it isn't, then a 504. This is because 504 is focused on access to the education, getting them able to be in the building, getting them able to receive instruction. Whereas IEP is focused on increasing the results, making them hit goals academically, bettering their performance. Now, IEPs have additional procedural safeguards in it, so it is a more effective tool with more rights. However, keep in mind that once a child has been determined to be eligible for an IEP, the parent or school, neither can choose, well, let's just give them a 504. IEP is above, 504 is below, so to speak. Once you're eligible for IEP, that's it.
Generally, what are my options if the school does not follow the IEP?
Generally, the options if the school is not following an IEP are twofold. You have a state complaint and then due process. The state complaint is a complaint filed with Virginia Department of Education stating the reasons why you feel the IEP was not followed or the other problems inherent. The state will come out, they'll investigate the school, and then they will state whether or not the complaint was founded. If the complaint was founded, you'll receive some sort of services to make up for the problem. Due process, it's legal proceedings, strict deadlines, and once you get to the hearing, you'll be before a hearing officer, you'll present evidence, flood them with documents, examine witnesses and cross-examine, and ultimately the hearing officer will issue his opinion.
Was the Virginia amended IEP only in effect for the 2019-2020 school year? If so, does our child revert back to the last agreed upon IEP at the start of the 2020-2021 school year? Please also address this for a 504 plan.
March, April, June, it was an emergency time period. Schools are scrambling, and we were receiving guidance from Virginia Department of Education, the Federal Department of Education, and in those guidelines, it did state the services and accommodations that are provided could look different. Now, we have not received any guidelines yet for this virtual schooling, but presumably, because we've had time now for the schools to prepare, to be out of this emergency scenario, the services they receive should be the same as the last agreed upon IEP. Now, I caution, during that time period, from March, April, May, June to today, If you have signed an IEP with less accommodations than you previously had, that last agreed upon IEP will be that one you most recently signed. If instead you did not sign one, they're merely changing some accommodations due to the emergency, a la the guidelines, then that will not hold any longer. It should be the last agreed upon IEP or 504 plan, which would be the same.
My jurisdiction has chosen to provide a virtual education during COVID-19. Does that absolve the school of their duties to my child under an IEP?
Virtual education does not absolve a school from following the IEP, from following their requirements under the law. They legally need to provide those accommodations and those services.
My request for private placement for my daughter, a level 2 education student, was denied. Can I appeal that? And what does the process look like?
I would strongly urge you to speak with an attorney regarding this issue because it can get very complicated and potentially could lead to a hearing. Now, private placement is the goal of many, many families with children that have special needs. And a lot of due process occurs because of this desire. If it is denied, you can continue to work with the school to discuss with them, hope that they come around. You can take drastic action of withdrawing your child and paying for it yourself, and hope after filing due process, a hearing officer will award you the previous tuition. Or you could file due process as it is to state that they are denying your child a FAPE by not placing them. However, because we're discussing a legal scenario, discussing litigation, speak with an attorney because there are many details that could swing it one way or the other.
My child's need for speech therapy under an IEP cannot be met virtually. Can I have the jurisdiction pay for these services?
My first question is the speech therapist in the IEP still? If it isn't, then you need to discuss with the school to have it put back in. If it is still in the IEP, then they need to provide that service. What that looks like in this virtual situation could be different. It might be a speech therapist coming to your house. It could be you going to a speech therapist's office to provide the services there. But regardless, if it's in the IEP, they need to provide it.
What are my options if the school delays my IEP meeting?
When an IEP meeting is requested, or an annual IEP meeting is coming up, there are deadlines that need to be met. Unfortunately, delays can occur that even push it beyond that. These are procedural violations. Unfortunately, procedural violations such as these don't rise to a level of a state complaint or to due process. However, if it continues to happen again and again, death by 1,000 paper cuts, you may have a complaint then if it continues to happen. However, in the interim, knowing you need the meeting, one possibility could be to hire an attorney, as once you do bring an attorney into the case, the schools tend to snap to attention and start watching their P's and Q's.
My child has a 504 plan. What rights do I have regarding addressing accommodations for virtual learning?
Under a 504 plan, the accommodations for virtual learning are going to look very different than what they previously have. As stated, 504 is about access to the education. So if you have a physical disability, such as needing to be in a wheelchair, previously you would have requirements for ramps and accommodations such as that in the 504 plan. That won't be required as much in a virtual scenario. However, let's say an individual has Crohn's disease. Maybe then a reasonable accommodation could be recorded sessions in conjunction with the live, so they can pause, rewind, and still watch the entire live stream. So the rights then for the 504 plan in this virtual are just as strong as they have always been. You just need to be creative and potentially bring in an attorney for some of those new solutions because it will look different.
Can a school change a 504 plan without permission from the parent?
Generally, no. A school cannot change a 504 plan or even an IEP without the parent's permission. If they wish to change an accommodation, a goal, or add information into the present level of performance, they need to hold the IEP meeting, discuss it with the parent, and have the parent or guardian sign off on the change. If that does not occur, then the last agreed upon IEP still controls, or the last agreed upon 504 still controls.
If parents do not believe their child will receive an appropriate education virtually, should they sign the amendment to their child's IEP or 504 plan if the jurisdiction requests it? What guidance would you give?
Agreeing to an amendment to an IEP should not be taken lightly. Because of that, an attorney should be sought to discuss with them your options and whether or not this amendment would be for the best for your child. The concern regarding the virtual education is reasonable, but we would need to know then what changes are they making in the IEP to reflect that. So because of that, and needing to know the full facts, strongly suggest speaking with an attorney regarding this.
How do we request an IEP evaluation in a virtual learning environment?
You can request IEP evaluation the same as you always have. Contact the administration and request for your child to be evaluated to see what eligibility they may have. Under this virtual learning, it hasn't changed. There have been some concessions made, primarily being able to conduct meetings virtually. So that way the entire team does not have to be in the same physical room.
Hypothetically, my middle school son has been denied a 504 plan for his ADHD because there is not an educational impact. My understanding is that we do not have to let kids fail before we give them a lifeline. What are my options?
If you're requesting a 504 eligibility and the school's denying it because of a lack of educational impact, you should strongly consider consulting with an attorney. As I stated earlier, IEPs require educational impact. 504 does not. This type of scenario could be a strong contender for a due process claim because they are actively denying eligibility for something completely unrelated to the law.